Hello friends, I have come here again to tell you about a latest ruling of the Supreme Court, K.S. Manjunath versus Moorasavirappa, which was decided on 10th November 2025. You remember last year, I gave you one ruling of R Kandasamy versus T.R.K. Sarawathy, in which it was held that in the absence of a prayer by plaintiff seeking a declaratory relief to declare the termination of agreement of sale as bad in law, a suit for specific performance of an agreement for sale will not succeed. Means, if there is an agreement of sale, the specific performance of which is desired by the plaintiff, and before filing of the suit, the defendant has already given a letter that the agreement of sale stands cancelled, then the plaintiff seeking specific performance has to seek annulment of that letter or order of the defendant cancelling the agreement for sale. Otherwise, his suit for specific performance will fail. But now, K.S. Manjunath has come and a new proposition of law has been given to us. Firstly, unilateral termination of agreement to sell is impermissible in law except in terms of Section 14 of the Specific Relief Act. Secondly, if the contract itself gives no right to unilaterally terminate the contract or such right has been waived and a party still terminates the contract unilaterally, then non-terminating party can directly seek specific performance without first seeking a declaration of annulment of the illegal order of termination of the agreement to sell. The Supreme Court in this case decreed the suit for specific performance, but in view of the passage of 18 to 25 years, also directed that in addition to the payment of the sale consideration of 18,83,000 with 16% per annum interest, the purchaser must also pay an amount of rupees 5 crore to the seller. Now, you only need to understand what is the implication of Section 14 of the Specific Relief Act, which says that the following contracts cannot be specifically enforced. 1. Where a party to contract has obtained substituted performance of the contract. Second, a contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. Thirdly, a contract which is so dependent on the personal qualifications of the parties that the court cannot enforce specific performance of its material terms. And fourthly, a contract which is in its nature determinable. Now, here again, please be cautious. If the contract confers upon a party the right to terminate it under certain conditions, and if such right is exercised, then the continued subsistence of the contract becomes doubtful. In such cases, the plaintiff has to first obtain a declaration that the termination is invalid before seeking specific performance. So, my dear young lawyers, understand the correct legal position and implement it in your practice. Thank you.